there is a very big question in Indian society. When rape is a crime, when sexual assault is a crime, why marital rape is not a crime? So rape is a criminal offense, then why not marital rape? Marital rape in India is decriminalized. Why marital rape is decriminalized in India? So it's a topic which is of huge debate. It's a continuous topic. Why? Because Indian culture believes that the institution of marriage is sacrament. The institution of marriage is very, very sacred. So in that marriage, the marital rape is accepted. But it is blatant violation of privacy, right to privacy. It's blatant violation of right to have a sexual orientation. It's complete violation of right to have a sexual intercourse with the person whom he or she likes. Mainly with respect to she, the marital rape concept is with. So here in this context, marital rape is most expected in UPSC interview, as well as in ethics paper, as well as in essay paper, also in general studies, Indian society as well. So holistic concept on marital rape. So what is the marital rape? That I am going to discuss in this particular session. First, I will give you the factual information. According to National Family Health Survey, which is conducted very recently, according to National Family Health Survey, the family is most dangerous place for a woman. The family itself is a most dangerous place for a woman. How I can tell? According to the National Family Health Survey, it told that 82% of the current husbands are responsible for marital rape, or within the family, or within the house, or within the residence. 82% of the current husbands are raping his own wife against her wish. That is called as marital rape. So 82% are husbands, 13.7% are former husbands. Means a former husband who got divorced, but he's grabbing the opportunity to rape the woman. 1.6% current or former boyfriend. 1.4% immediate family members, also within the family. So the rapes which are happening within the family, in that 82% are current husband, means what? Marital rape. And 1.4% are immediate family, like brothers, or 0.2% like strangers, like watchmen, etc. So in the family level, when the rapes are happening in the family level, 82% of the rapes within the family, or 82% of the rapes within the house is made by the husband. So what is rape, sir? Against the wish of any woman is called as rape. What is sexual assault? Which is done by force but not by consent is called as sexual assault. And the sexual assault within the family, or the sexual assault within the house, is more by the current husband. So the current husband is 82%, hence the marital rape is very, very high under the concept of National Family Health Survey. So why is marital rape legal in India? Why we are accepting marital rape as a decriminalized thing? Why we are accepting the husband can do anything to the woman? Why husband can do anything to the wife? It's not with religion, it is not with the region, it is not with the culture. In almost India, the 82% of the husbands in different states, in different religions, they are seeing the woman as the property of the husband. So because of which there is marital rape. So continuation with it, I am going to discuss what is the marital rape and why it is in the news. So something might be happened, why it is in the news. Recently Delhi High Court gave a verdict in batch of petitions challenging the exception provided in marital rape. So the Delhi High Court had gave a judgment that in rape, why you exempted marital rape? Why? Because Section 375 of Indian Penal Code talks about rape. Section 375 of Indian Penal Code talks about sexual assault. In that sexual assault, it's very clearly told that any man against the consent of the woman, if he forcefully participate in intercourse, that particular activity is called as rape or sexual assault. But there are two exceptions under Section 375 of Indian Penal Code. The two exceptions are: number one, for any medical interrogation, if there is a necessity for having an intercourse or for some medical purpose, they can go or they can consider it as not a rape. So for medical thing, there can be intercourse which cannot be considered as rape, number one exception. And number two exception very clearly mentioned that the husband intercourse within the family, if the wife age is more than 15 years, it is not called as rape. So section 375 very clearly told that a marital rape is not a rape. So the High Court of Delhi gave the judgment saying that within the rape definition, why you are not adding marital rape? So it asked a question. It didn't give any judgment. It asked the question that why you people are not adding the marital rape within the definition of rape. So any judgment or any discussion or any ruling which is given by the High Court, it can be discussed in the same High Court with the larger bench, or else the same judgment can be questioned in Supreme Court of India. So now the Pandora box has been opened. What is the Pandora box means? We can go to any larger bench within the Delhi High Court, or now there's a chance to go for Supreme Court of India questioning the legality of marital rape. So because of this judgment of Delhi High Court, it is in the news. So sexual intercourse with one spouse without the partner's consent is referred as marital rape. A sexual intercourse of a man with the spouse without the consent is called as marital rape. So Indian law, according to Indian Penal Code, marital rape is not a crime. Marital rape is not a crime. Hence the debate. Hence the issue. So the debate is whether we have to consider marital rape as a legal thing or marital rape as illegal thing. Whether marital rape should be criminalized or marital rape should not be decriminalized or should not be criminalized. Whether marital rape should be criminalized or marital rape should be decriminalized. So the question is open here whether we have to call it as a criminal activity or whether we should call it as a decriminal activity. Hence we are discussing about the same. So section, listen carefully. So section 375 of Indian Penal Code talks about rape. Talks about rape with two exceptions. Number one is a medical procedure or intervention shall not constitute rape. So for medical purpose, if any intercourse is happening, it is not called as rape. Number one. For example, when they want to remove the ova or when they want to test something, if they put something in the vaginal system of the woman, it is not considered as rape. First exception. Second exception is sexual. This is what the debate all about. The debate is about this: sexual intercourse or sexual acts by a man with his own wife. Sexual intercourse or sexual activity by a man with his own wife. The wife being not under 15 years of age. It is what? Exempted. It is what? Exempted. Under section 375 means what? It gave a legal right for the husband to force his wife for a sexual intercourse. Hence it is leading to inhuman, draconian as well as inhuman treatment which is happening on the woman. Hence such type of activity in the civilized society, such type of thing in independent India, whether we have to continue it or not is subjected to debate. So this is what which is present according to the law. So section 375 very clearly telling that any sexual course, any sexual intercourse, if there is an exemption for medical intercourse, for medical intervention, and if there is an exemption for husband on wife. Is marriage a license to rape? Is marriage a license to rape? So whether men is feeling the marriage is nothing but he is getting a license to go for sexual intercourse with consent, not a problem. Without consent, it is called as marital rape. Marriage is not a license to rape. Consent is everything. It might be within the marriage relationship or without the marriage relationship. The most important point is consent. The most important point is consent. It might be within the marriage, it might be outside the marriage. It might be any other woman, or it might be the wife. It might be anything. Consent is most important. Not only other women, it is the wife also. There is a necessity for consent. So there is no exemption for wife, but what the Indian law is telling, Indian law has exempted consent for wife under section 375. Hence, marital rape is rampant. It's an age-old practice. It's continued before independence. It is continuing now in the 21st century also. The marital rape is happening. Hence, the issue is in the news. I will give some facts. Facts about marital rape. What are the facts? Number one, according to National Family Health Survey, 5.4% of Indian women, 5.4% of Indian women reported that they experienced marital rape. 5.4% of Indian women, married Indian women, they had reported that we are being experiencing marital rape. Means what? Forceful intercourse. Number one. Number two, of 185 countries in the world, 77 countries have laws criminalizing marital rape, and 74 countries are having some or the other legal provision to file a complaint. The remaining 34 countries decriminalized directly. Remaining 34 countries decriminalized directly marital rape. So in this context, India belongs to this 34 countries, where Afghanistan is present, where Pakistan is present, where Bangladesh is present, where Nigeria is present. So all the undeveloped countries, India is standing with them. So in the 21st century, independent India, the sovereign India, whether the marital rape should be continued or not. These are the facts regarding marital. So, arguments in favor of criminalizing marital rape. What are the arguments? Arguments in favor of criminalizing marital rape. Number one, the first and the foremost, blatant violation of Article 21 of the Constitution. Clear-cut violation. Right to sexual intercourse, right to choose a partner, right to have a body, right to privacy, right to have autonomy on her body. These all are violated. Why? Because the body is her. The body belongs to she. Right to her own body, right to her own choice, right to her own privacy completely got violated under marital rape. Article 21 got violated. Complete violation of fundamental rights under Article 21. Hence, there is a need for criminalization of marital rape. Number one. Number two, an infringement of right of bodily autonomy. You leave about the Constitution. This is my body. Woman, this is my body. Another man, how can force on my body? Why? Because this is my body. This is my private parts. This is my privacy. How another? It's a common thing. It's a human right. It's a natural right. It's a universal right. It's a universal human right. How any other man can force on me just because of doing marriage? Hence, these arguments are supporting criminalization of marital rape. But there are some Supreme Court judgments. So here I am going to discuss about Supreme Court judgments. What Supreme Court told? What Supreme Court told periodically with respect to marital law or marital rape? What the Supreme Court told? Number one, in the Joseph Shine versus Union of India case 2018. Joseph Shine versus Union of India 2018, Supreme Court very clearly told that adultery is a decriminalized. Adultery was decriminalized. Supreme Court struck down adultery. Means earlier, if any married man, unmarried woman, married woman, unmarried men, both married and married men and married women, if they are in sexual intercourse relationship, it is called as adultery. Before 2018, adultery was a criminal offense. Before 2018, adultery was a criminal offense subjected to penalty, arrest. But in 2018, Supreme Court told that right to sexual intercourse cannot be criminalized. Why? Because it's the choice of the individual. It's the choice of the individual. Marriage is just a contract. Marriage cannot bind. Marriage cannot bind with whom they can intercourse or with whom they should not intercourse. Hence, adultery was being removed as decriminalized and told that husbands are not the masters of wives and wives are not their husband's property. So wife have her own choice, husband had her own choice, but however, adultery can be used as a weapon to get divorce, but it cannot be criminalized. It cannot be a weapon for a criminal case. It can be a matter for divorce. If any adultery is there on husband or any adultery is there on wife, you go for divorce. There is no necessity to go for a criminal case. Why? Because it's a choice of an individual. On the same lines, we can tell that when you are telling adultery is a choice, in the same way, the wife also have the choice whether to have an intercourse with the husband or not. If without her consent, if husband is also going for intercourse, it should be also decriminalized. The first judgment, Joseph Shine versus Union of India. The second judgment is in state of Maharashtra versus Madhukar Narayan case, that every woman has a right to have her sexual privacy and that no one has the right to invade into her privacy whenever they like, including husband. It's her choice. State of Maharashtra versus Narayan case. Madhukar Narayan case, the Supreme Court very clearly told that it's the choice of the wife to when to have an intercourse, when not to have an intercourse, or it's the choice of the husband also when to have an intercourse, when not to have an intercourse. No one can force another man. Hence, another progressive judgment regarding marital rape. So when you are telling that is the choice of the individual, then when husband is going against the wish of the wife, then why you are not considering it as criminal offense? Third judgment. The state of Karnataka versus Krishnappa judgment, that sexual assault is demeaning act in addition to being violation of someone's right to privacy and sanctity of their own body. It is a sexual assault which is demeaning. Sexual assault is not at all valid. Sexual assault is not at all acceptable in the civilized society. Why? Because in civilized society, what is most important is consent is important. Hence, the Supreme Court came multiple times saying that it can be a marital rape or it can be any other act which is against the consent is not at all acceptable. But there is a no clear-cut law which is telling that marital rape is a criminal offense. These are the Supreme Court judgments. So, three judgments you have to remember. Number one is Joseph Shine case versus Union of India. Second one is State of Maharashtra versus Madhukar Narayan case. Third, State of Karnataka versus Krishnappa case. What United Nations told, what the way forward is. Way forward, United Nations told that United Nations has urged countries to end marital rape by closing legal loopholes. What is a legal loophole? Marital rape is not considered as a rape. To close the legal loop, saying that the home is one of the most dangerous places for women. And that home can be safe if marital rape is been made as a rape, according to United Nations. Second, way forward, according to Justice J.S. Verma, J.S. Verma committee was been constituted in 2013, aftermath of Delhi rape case in 2012, and this J.S. Verma committee has been given a list of recommendations. On the recommendations, Criminal Law Amendment Act 2013 was been made, and this Verma committee has recommended to make marital rape as to be called as illegal or legal. So it told that the marital rape should be illegal or legal. What it is called as? It is called as illegal. Means what? Marital rape should be criminalized. Marital rape is not legal. Marital rape is illegal. When anything is illegal, it can be criminalized or not? It should be criminalized. These are the judgments of, these are the way forward of United Nations organization as well as J.S. Verma committee, which was been constituted aftermath of Delhi rape case. Arguments against criminalization. No, criminalization should not happen. Arguments against criminalization of marital rape. So what are the arguments against criminalization of marital rape? Number one is the government in 2015 very clearly told that, raised over criminalization of marital rape. It told that if marital rape is criminalized, it would destabilize the institution of marriage. In India, marriage is a part of basic culture. Marriage is a part of basic culture. There is a chance that marriage as an institution can be broken into pieces because there is a chance of misuse. That is also there. There is a chance of misuse whereby the wife can use it as a weapon against husband. So complete institution of marriage can be collapsed because there might be a situation whereby the husband might be worried or feared to get married to the woman. Why? Because woman can give a complaint on marital rape. So the government in 2015 told, in longer run, when we have a broader perspective, there's a chance that the institution of marriage itself can break into pieces. If the woman is positive, if woman is good, yes, marital rape should be criminalized. If woman is negative, if woman is bad, then the husband life will become disaster. So there is a chance of misuse of law. There is a chance of destruction of complete marriage system. So hence the government of India in 2015 told to the Supreme Court that we cannot make a law criminalizing marital rape. Also told it would affect the social fabric. So we have a social fabric whereby marriage is a main part of the social fabric. The marriage itself can be collapsed and hence needed a wider consultations. Hence now we cannot criminalize marital rape. Hence we need more wider consultations, which is told by the government of India in 2015. These are arguments against criminalizing marital rape. Then what, sir? Then what Law Commission told? Law Commission 2000 told. Law Commission of 2000 told that need to remove this marital rape exception was rejected and recommended to criminalize marital. It told, Law Commission of India also told that yes, there is a necessity to criminalize marital rape. But the government of India is not taking any initiative with respect to it. But however, we have to understand that in this particular 21st century where liberty, freedom are given importance, such type of inhuman activity or showing masculinity or showing hegemony of men on women after the marriage is completing demeaning the word of sovereignty or autonomy of the individual. It's a blatant violation of Article 21 of the Constitution, and hence there is a need to criminalize marital law. But however, just by criminalizing marital law, it is not enough. There is a need for cultural change. Why? Because if any woman go to a police station to give a complaint on marital rape, the police himself will talk in such a rudimentary way that the woman will not dare to go to the police station. There is a need for cultural change. There is a need for behavioral change among the law enforcement agencies as well as the judiciary, such that the woman can enter into the judiciary or the woman can enter into the law enforcement agencies' offices, and whereby she can give a complaint with a free and fair mind. This will be the conclusion of marital rape. Finish. Yes, Bhavani, what is your opinion? Something you are telling, no? Tell you. Tell. Louder. Chol na mado. Marital. Domestic violence is civil offence. Domestic Violence Act of 2005 is civil case, whereas rape, the word rape itself is criminal offence. In domestic violence, we don't talk about sexual violence. Sexual violence is something different. In domestic violence, we talk only about physical violence or mental violence. Only two types of violence are there. One is physical violence or mental violence. For example, domestic violence. You asked a husband for pocket money. Wife asked her husband for pocket money. If husband is not giving pocket money, it is a mental torture. It can be a base to give complaint in police station on Domestic Violence Act. So there is physical violence and mental violence. But sexual violence is very severe. Domestic Violence Act is civil case. Civil case, no arrest. But other than domestic violence, like Section 498, Section 375, Section 497, earlier adultery, these all are criminal offence, direct arrest. But now Section 497, which is adultery, is also decriminalized. Yes. Sir, why is age for sexual intercourse still 15 when age of marriage is 18? This is what. Section 375 is not amended yet. It is only for marriage. See, if I give a complaint, it's a case. Legally, when I am getting married, I can get married. Any woman can get married at 12 years or 13 years or 10 years. But there should be what? To take a cognizance. Complaint should be there now. Complaint will not come. So section 375 is telling that sexual intercourse with the girl who is above 15 years is not called as rape. That means below 15 years is called as rape. It might be wife also. So they gave a condition 15 years under section 375. But however, they made a new law which told that the age for marriage is 18 to 21. If there is a complaint, then only there will be an issue.